Hello and welcome back to the Argyle GCCLO Summit. My name is Vicki Lynn with Argyle. It's great to have everyone joining us. I have some important information to share with you, then we'll turn the floor over to our esteemed keynote speaker. To ask questions throughout the session, simply type into the Q&A and you'll see on your screen the Q&A chat, and we'll address your questions at the end of the session. And now, without further ado, I'd like to introduce our speaker, Scott T. Lashway, partner, co-leader of privacy and data security practice at Manette. We're so excited to have Scott with us for his keynote presentation titled Protecting Company Data, Emerging Global Data Privacy Concerns. Welcome, Scott, and over to you.
Thanks, Vicki Lynn, and good afternoon, everyone. So I'm going to kind of take you through some slides. There's a lot in here. We're not going to cover all of them, but they are intended for your consumption and sharing, and happy to follow up with any questions that I can't answer on today's session if you'd like to connect otherwise. If you do have questions, as Vicki Lynn noted, please put them into the chat. I'll take them as I can, and we'll reserve 5 minutes at the end to get through as many as possible. This really is intended to try to talk about the practical implications of serving as a general counsel and a chief legal officer at your organization when the constant conversation across industries is cyber and privacy risk is in the top 5. The material risks at an organization, whether you deal heavily in data and technology or not. And we all know it's at the forefront of board members and investors' attention. So let me just walk you through just a little bit of kind of where we are as industry leaders on the legal risk and why we're constantly having to play catch up. So it's a never-ending treadmill of risks, and it's a never-ending treadmill of emerging technologies and new use cases for data and how our organizations conducts ourselves and conducts our businesses. That never-ending treadmill, of course, implicates legal risk constantly along the way, not just because of the emergence of new regulations in California and Colorado, Connecticut, and Virginia, but also because of old laws that have been existing on the books, some dating back to the 80s, some predating the 80s that are now being applied to new technologies or being applied to old technologies in new ways. Things like wiretapping statutes out of the 80s and the Computer Fraud and Abuse Act out of the 80s being applied to interacting with websites and services provided through the internet. So it's constantly playing catch up on that treadmill. There's a lot of conversation amongst technologists about this is how the risk presents itself at an organization. And a lot of that risk in that conversation is focused on operational risk. Ransomware is the one that gets the most attention. And if you ask your IT professionals, they often have 2 reactions. Yeah, we're all over it. We know ransomware. We've seen it. We've read about it. Or, gosh, it keeps us up at night. And the problem with these risks is that it's not just what you're reading in the headlines. It's even the small risks. We deployed new technology and it wasn't implemented properly, not because we made mistakes, but because we just didn't implement it correctly. And that's operational risk. Do our systems actually work? That all materializes in legal risks oftentimes without us knowing about it. So without the GC, the CLO, the legal department being aware that the technology is being implemented, being aware of what the technology does with respect to our cybersecurity program and stature or data privacy program. But all too often, the conversations are focused on very particular vulnerabilities, and we identify a couple of them here, or very particular laws. Well, we got to go comply with the CCPA, or we have to comply with the European Union's GDPR. As a GC or a CLO, I would encourage all of you to take not so much the myopic view, but more the strategic view, and understand your organization's strategy for addressing these risks. But first, you have to identify them. And that means you need to have someone available to you that can actually speak not just to the operational risks of cyber and privacy, but to the legal risks. How does this bubble up into a litigation? How does this get in trouble? How do we get in trouble on a contracting basis or a violation of a law that I never thought in a million years would ever apply to us because we're running a website. And those conversations can be difficult to get to, but one of the things we want to speak to today is how do you actually keep abreast of what the risks are from a legal perspective? And it's not just keeping track of what the CCPA or what Virginia is doing or what the 12 or 13 other states that currently are considering privacy laws are doing. It's understanding that world in which you work. So interestingly enough, you see things like legal risk coming through contracts. So we're often focused on statutes. Here in the US, we talk a lot about whether there'll be a federal privacy bill. Whether there will or won't be, it will not solve the problems that you have to face within your organization because the legal risks come from elsewhere as well, not just whether you have to comply with a state law or 50 state laws or a federal law that usurps the state laws. They're baked into just about every contract you have with your vendors and just about every contract through which you're providing your goods and services. Oftentimes, those contracts create a lot of challenges for us to understand what is the real privacy or cybersecurity risk in my organization? Do we even have a handle around it? Do we have a template for this kind of risk and contracting that we should work from so that when the risk materializes, we have a basic understanding of our position on these things? Do we have provisions that contemplate privacy and security risk that are focused on choice of law? Is it okay to choose California as your choice of law or your preferred jurisdiction in contracts for litigation? I would encourage you to think twice about that relative to where the California courts are and where their legislature is with respect to regulating this risk. And this is going to be a constantly evolving thing. A lot of people choose New York and Delaware law, and I think you have to ask yourself these days, that might be good for the corporate aspects of my contract. Is it good for the data, the privacy, and the cybersecurity risks of my contract? Then you get into things like, well, we're migrating to the cloud. And what does that actually mean from a CLO or GC's perspective? And do I need to pay attention to these types of overhaul to our company systems? And of course, the answer from my perspective is yes. Not just because there's significant contracts often, but you are exposing yourself to someone else's computer technology, and you need to have an understanding of whether that technology is an improvement on your own abilities, your own ability to mitigate that risk, and what's happening with that risk when it materializes. So if you move to one of the big public cloud providers, there's 4 or 5 of them that are out there, your ability to really navigate their contracting language is less than if you're moving to a more smaller application that uses cloud services. And these are all things that can be developed and thought through in advance. So you walk away from this presentation and you think, well, geez, I understand we're moving all of our environment into the cloud. I wonder if the team who is moving it into the cloud has consulted with legal, my department, or me, to understand what the potential legal risks are. And they come, again, from all over the place. So, for example, we hear often you can't process US data offshore. In some industries, that may be true. In other industries, it's probably not true. I hear, well, if we process it offshore, then that's going to greatly increase our cybersecurity posture. For some industries, probably true. For other industries, probably not. If you're using certain cloud providers, probably true, versus other cloud providers, probably not. Whether you can actually process the data offshore without implicating privacy laws, like GDPR, is an important question for which there are potential very significant fines. So these are just examples of where this risk is materializing on a daily basis for even what I would say are the most strategic or tactical implementations of technologies within your organizations. So things that chief legal officers and general counsel can use, some tools that they can use to help you understand what's going on in your organization. And we highlight them here. Each of them are different kind of strings you can pull to not just understand what the risks are, but then to develop some strategies and tactics from a legal perspective to help your organization mitigate what that risk is today and what the risk is when it materializes. We have state laws everywhere. We've got a mix of regulatory guidance and industry standards. Each of these may or may not apply to you, but the concepts likely do apply. The state breach laws are one that we often focus on retrospectively. We call that the mop-up operation after you have a cybersecurity incident, whether you have to notify people, but it's not just the breach laws that are implicated anymore. You may have industry-specific regulations that require you to notify a specific regulator, a banking regulator, an insurance regulator, a healthcare regulator, whatever it may be. You might be a federal contractor for which you have contractual obligations or regulatory obligations to notify the federal government. You also likely will have third-party contractual obligations where you have a vendor or you're providing service to someone and they expect a pound of flesh and notification immediately, all in the context of you trying to figure out the world. So here's a question. Does the patchwork of differing state privacy and data security laws increase the vulnerability of companies to a breach? Would there be a benefit from a single federal standard? So the short answer from my perspective is yes, there should be a single standard applied in the United States with respect to notifying individuals for a data breach. And that can be very prescriptive. One of the problems we face here in the US is we don't have our house in order. I think we fail to understand from a Western nation that our companies are standing at the front lines of national warfare, right? So one of the things I wanted to talk about in a minute, but I'll get there now, is we are regulating privacy, consumer privacy, and I have the CCPA or a piece of it up on the screen now. We are regulating that in the context that consumers in certain states in the US have fundamental rights to keep their data private. And a lot of this data, of course, is on the internet. Other states haven't given those rights yet by statute, and the federal government does or doesn't, depending on your reading of the US Constitution, provide these rights as fundamental rights of being a US citizen. Data breach laws regulate the security of that data, not necessarily the privacy. So when the security of that data is breached, you have to notify the individual that XYZ happened under state law. I think that would benefit from a single federal standard, but it doesn't necessarily dictate whether or not individuals in the US are entitled to privacy to their personal information wherever they may go, into whom they may share it, right? So it's not information that was readily available until someone made it available on the internet or otherwise. How does a company possibly navigate all the local and ever-evolving local laws in different industry and regulatory standards? It's completely overwhelming. Any advice? We get this question just about every day from new clients who say, can you help? There's a snow globe effect to all of this, meaning you can't take your company and shake it up. And we have 5, 10, 25 laws that may apply and say, well, geez, this is how we're going to have to do business going forward. Some people call this privacy by design. You could call it security by design. I think first and foremost is do an assessment from your legal perspective to say what laws could possibly apply to our business. Look at your internet usage. Are you selling services through it? Look at where you're doing business. Am I doing business in California such that the law, the privacy law, the CCPA is going to be applicable? Understanding where those risks come from, and that doesn't need to be a significant exercise at first. It could literally be a piece of paper to understand, here's where our data is, here's where our technology is, and I'm going to look and start thinking about the laws that may be implicated. Hiring a professional outside privacy and cybersecurity counsel or hiring one for your team is a wonderful place to start. We do this for clients every day. It's not a huge exercise, but at that point, you can then start understanding the risk and understand how to potentially pay it down. So a good segue to what's on the screen, California allowed an exemption for employment data and business-to-business data that was in the CCPA to expire last August when the legislature took no action to extend the exemption. So in short now, the CCPA, or as some call it, the CPRA, which is amended as of January 1st of this year, now regulates consumer information and data, employment data, and business-to-business data. So individuals, vendors, customers, and partners with whom you're doing business. and they provide those same rights to those individuals throughout the statute. We have Connecticut, Colorado, Virginia, and Utah, all of whom have come online. I think there's going to be more. There's activity in more than a dozen states right now, and their legislatures looking at privacy bills. Some of them seek to regulate privacy for consumer purposes. I think there's going to be continued attention to regulate privacy for national security purposes. We'll likely see a lot of that discussion led by Washington. That would be, for example, not or restricting the availability of US citizens' data on certain technologies or certain companies who are based in countries or geopolitical places that are adverse to the United States interests from operating, say, on our government's infrastructure, or at least indicating that this is an entity that's being operated by a foreign nation state, and you should be wary of doing business with them. We see it now with respect to some social media companies. It's going to continue. And then we also see, privacy rights being extended as a fundamental right as a human. And these are things that the Europeans have acknowledged when they enacted the GDPR that went into effect in 2018. And I think you'll see states doing that here in the US. It may come out to a purple, blue, red state, but it's not particularly clear. You'll see red states like Texas and Oklahoma that have considered consumer privacy bills that have advantages for businesses. We've seen Florida get close to adopting a privacy bill that supposedly got hung up because of a fight over a private right of action for plaintiffs' lawyers to bring a lawsuit. So there's still a lot of battlegrounds being found in the states, and of course in Washington, it's a continued conversation. The key here from the GC and CLO's perspective is making sure you're not running a program that has 50 different rules. You want to find common ground across the applicable statutes, whether they be privacy bills or wiretap statutes or the Computer Fraud and Abuse Act or healthcare statutes at the federal or state level, in understanding and defining what those rules are for your handling of data in your maturation of your technology program. So I'm going to jump just for a minute as I look at the clock. Here are a lot of people say, well, where is cyber legal risk? Isn't this just really operational risk? And we often will immediately push back, of course, and say, no, cyber risk really does partly belong in the law department. I don't think the law department needs to own it. The law departments don't often own risk in most organizations, but we need to be intelligent and smart and informed on how we counsel the business in identifying the risks and containing it and allowing them to accept it where they want to. So we've got the breach laws that we spoke about. We've got privacy and cyber regulations focused on the three things that we spoke about. But then we've got your common law claims, which drive a lot of this. So I've been asked questions like, well, when we have cyber risk and we're aware of something that happened, do we actually have to investigate? And the answer is somewhat complicated. There are laws that require you to provide breach notification. So that's an example of why you need to investigate. But there's also fiduciary responsibilities of an organization. Depending on which state you're in, they can be different, of course. But those fiduciary obligations arguably could extend to the organization, making sure that it handles its assets with care, and ensuring that the integrity of those assets, the value of those assets is available to the constituents of the organization to use for business purposes. So making sure your computer systems and everything the organization has invested in those systems is operable and is free and clear of interference or compromise. And we give you a few other torts and other common law claims that we are regularly defending on behalf of clients. And then we give you a whole bunch of statutory claims to consider too. These are just some examples of where your cyber legal risk may materialize and you want to get out ahead of it. A lot of folks have gone to cyber insurance historically and said, well, I can't afford a cyber or privacy program that's going to give me 90% of the defenses that I think I need. So let's ensure whatever remaining risk or latent risk that I'm not aware of. The challenges here are that the cyber the cyber insurance market is a little bit turned upside down. They've experienced significant losses through ransomware attacks. Premiums need to go up to cover the pooling of that risk. And cyber insurance is never intended to insure an organization's failure to adopt basic best practices on making sure your organization has a data privacy program or a cybersecurity program. It was meant to help with the latent risk, not 100% of it, as some organizations were using it in our view. And so the market is increasing premiums, has been unwilling to underwrite a lot of companies, including in major industries like healthcare and elsewhere. And so the ability to rely on insurance to cover this risk, both from a monetary perspective, can you get enough coverage, and a substantive perspective, can you get the right coverage, is a lot more challenging these days than it was even 12, 18 months ago. And we think that's probably appropriate. That risk should really be borne first and foremost by the organization and then shared with the insurers. The SEC has come to the table, and this gets to one of the earlier questions about, having a federal standard. Well, maybe the SEC thinks that making this information when material risk arises needs to be shared with the investing public. Of course, a lot of us have concerns with that, because anytime we put material risk out in the public, it likely exposes the organization to further material risk. So if I have to disclose that our multi-factor authentication isn't working properly or wasn't deployed properly, and therefore presented significant risk to an organization, until I fix the problem, the vulnerability, I don't necessarily want to be telling the world about it, including my adversaries who are standing ready to attack. So there's lots of consternation about the SEC's proposal, but they will take action in this space, and we all hope they're going to get it right. And I think they'll probably come as close as they can, and then it'll be adjusted further. There are courts that are now getting, of course, involved, but not just involved in an application of, say, someone stole a bunch of credit cards and should the company have to pay for that, or someone stole intellectual property and there's a couple tort claims that are involved. Courts are starting to look at, and in particular, Delaware courts, an organization's obligation from the board of directors down to management, down to its personnel, to deal with this risk in a real-time basis. And this is an excerpt from the Marriott case. If you want to read an opinion in the cyberspace that's outside of what's in the daily news, this is a great one to read. And it will get everyone's attention in the boardroom about why this risk needs to not only just occasionally bubble up to the board, but be present on a constant basis with the board, so they know fully what the company has been able to achieve and what it hasn't been able to achieve from a management perspective. Chancery just spoke again in late January about extending the Caremark obligations down to the officer level. Now, this is outside of the context of cyber, but something that we should all be paying attention to with respect to privacy and security risk. So this is another really interesting opinion in the context of privacy and security risk for a GC and a CLO to consider whether or not this risk needs to be better understood across an organization, not just within your security team, your CISO or your CIO or your CTO. I'm going to speed along here to open it up to some questions. But one thing I really wanted to hit, because I think this is important, is applying applicable legal privileges, which is a very difficult thing to do in your shoes. I was in-house counsel for a period of my career, and it's difficult to determine when privilege may or may not apply on any given day at any given meeting. We think and encourage you to think about this constantly with respect to this risk. Running gap assessments, testing of any kind, running tabletop exercises a part of all of that is to identify legal risk within the organization that could be in violation of contracts, statutes, all the things we've talked about. And in doing that, we think that privilege or work product protections absolutely may apply, at least to some of the work. And I would encourage you to think about that from your perspective. There's a lot more in here, but let me turn to some questions, and folks can peruse this or ask for a copy of it from Argyle. We all have data overload. How do we focus and prioritize understanding the data for which data privacy regulations apply and represent the greatest risk? So the first thing, and I kind of tried to get at this earlier, is you could do a balance sheet. What's the data we have? Where are we getting it from? Which is really important. And what are we doing with it? You could do 3 columns or a couple columns, and you could do it on a notebook. The places in the organization where I would go are your marketing department, understand what's going on with your website. I would go to the leaders of your businesses to understand what data they're using and whether any of it could be personal information. And I would go to HR. Those are the places where I would start. But also, to my message earlier, don't just focus on the data. So we've got personal data, which is privacy, but we also have a lot of other data, like our financial records and other things we care about. Turn the page over and do that with all of the information that you care about, and understand where that data is also stored. Are we storing it in the cloud? Are we storing it on premises? Are we storing it on people's laptops? If we are they encrypted? Are people walking around with personal information or financial information? Should they be? These are all kind of basic questions that we ask when we're doing an initial intake of a client. And there's no reason why you can't start that process, even if you're not an expert in this. Is there more significant risk with software as a service options? How can we assure our vendor is paying attention? I don't think there's more significant risk with software as a service. There's some phenomenal organizations out there who invest a massive amount of money in software as a service. And some of the leading cybersecurity companies globally are software as a service. I do think that if you're going to rely on third parties, you need to have a process, and here it's vendor management on the screen, that would allow you to understand with whom are you doing business? Have they invested the resources that you would expect? And do I have the right contractual liability, warranties, et cetera, built so I can protect my business and the people that I will have to answer to if that risk materializes? Question 4, which state is most litigious in terms of privacy? Do you feel that some states are now in competition to have the toughest standard in the nation? I think the answer to the second question is not yet. California is absolutely leading the way with respect to privacy. New York is absolutely leading the way with respect to cyber regulation for particular industries. That's their Department of Financial Services cyber rule. If you're looking for a great statute to read on cyber regulation, just Google New York State DFS cyber rule and read it, and you'll get a basic framework for what I think will be rolled out by other states going forward as to basic cyber regulation. I would not look at the CCPA in California as a perfect framework for regulating data. It was drafted in haste, including with typos. I think it's confusing as it's applied to most industries. And I believe it needs a significant overhaul to make it actually usable and not confrontational to how we do business, especially how we do business on the internet. In terms of states, California is by far the most litigious, probably will remain so, not necessarily because of the CCPA, but I think their court system has always handled a lot of personal injury and related consumer cases. Illinois would be the second with respect to their biometric. On any given day, there's somewhere between 225 and 250 cases pending in Illinois state courts with respect to what is commonly referred to as BIPA, their Biometric Information Privacy Act. I think I've answered all of the questions, and I hope this was particularly useful. Like I said, there's a lot more in the slide deck that we didn't cover in today's discussion. And some of it is built entirely for your utility after today's program. If you have any questions, you can find me on the internet, on Manat's website, and I'm happy to follow up to chat on my dime and hear about anything in particular that you're dealing with. So with that, Vicki Lynn and Lindsay, thank you very much for having me. I appreciate everyone's attention and time.
Thank you so much, Scott. What a information packed, super practical presentation. Thank you. As Scott mentioned, there's lots more information in the slide deck, so do feel free to contact Scott afterwards if you want any clarification on any of that information. And his LinkedIn is included on our site, his link, and of course, email right there on the screen. I want to thank everyone for joining us today for this fantastic session. And this session, along with all of today's content, will be available on demand following the event. And this officially concludes the Argyle GC CLO Summit. Thank you all again for joining today and engaging in our content, and have a great rest of the day.